Texas versus federal law. Why teens have more freedom to work here in 2026. This presentation compares Texas Labor Code Chapter 51 with the Federal Fair Labor Standards Act, the FLSA. We will cover hour limits, work permits, prohibited occupations, and the national trend of child labor law changes across America. This presentation uses official sources: the U.S. Department of Labor website at dol.gov, the Texas statutes at statutes.capitol.texas.gov, and the Texas Workforce Commission at twc.texas.gov. Let us begin. To understand what Texas allows, you first need to know the federal baseline. The Fair Labor Standards Act of 1938, or FLSA, found at Title 29 of the United States Code, Section 201 and following, is the foundation of all child labor protections. For 14 and 15-year-olds, the FLSA sets strict limits: 3 hours per day on school days, 18 hours per week during the school term, 8 hours per day and 40 hours per week when school is out, and work only between 7 a.m. and 7 p.m., extended to 9 p.m. in the summer. However, for 16 and 17-year-olds, the FLSA sets no federal limit on hours worked at all. It only prohibits hazardous occupations through 17 hazardous occupation orders listed in Title 29 of the Code of Federal Regulations, Part 570. State law fills the gap for hour limits. Here is what Texas state law says. Texas Labor Code Chapter 51, Sections 51.0001 through 51.016, covers the employment of all minors under 18. For 14 and 15-year-olds, Texas permits up to 4 hours per day and 28 hours per week during school weeks. During summer and non-school weeks, up to 8 hours per day and 48 hours per week. Work hours run from 5 a.m. to 10 p.m. That is more permissive than the federal FLSA on every measure. For 16 and 17-year-olds, Texas imposes no hour restrictions at all. No daily limit, no weekly limit, no time of day restrictions. No work permit is required. No parental consent letter is needed by state law. This is the key difference that gives Texas teens more freedom to work. However, the federal hazardous occupation orders still apply to all minors under 18, regardless of state law. Let us compare Texas and federal law side by side. For 14 and 15-year-olds, federal law allows 3 hours per day during school. Texas allows 4. Federal allows 18 hours per week. Texas allows 28. Federal allows 40 hours per week in summer. Texas allows 48. Federal hours are 7 a.m. to 7 p.m. Texas allows 5 a.m. to 10 p.m. On every metric, for 14 and 15-year-olds, Texas is more permissive. For 16 and 17-year-olds, both federal and Texas law have no hour limits. But Texas goes further by not requiring work permits for this age group. The only area where federal law is stricter is hazardous occupations. The 17 federal hazardous occupation orders at 29 CFR Part 570 provide comprehensive safety protections that Texas does not expand upon. Here is how the work permit system works in Texas. Step 1. The employer must verify the minor's age using a birth certificate, driver's license, or school ID. Texas Labor Code Section 51.014 requires proof of age records be kept on file by the employer. Step 2. For minors under 16, a work permit must be obtained from the school district. Texas Education Code Section 21.003 requires the school to issue a certificate of age. These permits are free. Step 3. A parent or guardian must sign the work permit application for minors under 16. No minor under May 16th work without signed parental permission under Texas law. Step 4. For ages 16 and 17, no work permit is needed at all, and no parental consent letter is required by Texas state law. This is where Texas diverges most dramatically from other states. Now, what jobs are off limits? Under the FLSA, 17 hazardous occupation orders, or HO orders, prohibit all minors under 18 from performing dangerous work. HO1 covers explosives. HO2 covers motor vehicle driving. HO3 covers mining. HO4 covers logging. HO5 covers power-driven woodworking machines. HO6 covers power-driven metal forming machines. HO7 covers meatpacking. HO8 covers power-driven bakery machines. HO9 covers balers and compactors. HO10 covers roofing. HO11 covers excavation. HO12 covers demolition. HO13 covers electrical work. HO14 covers radioactive substances. HO15 covers slaughtering. HO16 covers power-driven hoists. HO17 covers manufacturing bricks and tiles. These federal bans apply regardless of any state law. Texas is not alone in loosening child labor restrictions. Since 2023, a wave of states has rolled back protections. Iowa expanded work hours for 16 and 17-year-olds while adding employer liability protections. Arkansas removed work permit requirements. Ohio allowed later hours with parental permission. Missouri expanded hours while reducing paperwork. Florida in 2026 passed a law allowing 16 and 17-year-olds to work more than 30 hours per week with a notarized parental waiver. Texas has had no hour limit for 16 and 17-year-olds since before 2026, placing it among the most permissive states. What does this mean for Texas teens? Nearly 250,000 16 and 17-year-olds are already in the Texas workforce. The most affected industries are hospitality, retail, and agriculture. Supporters argue these rules provide workforce flexibility, reduce burdens on businesses, and help fill labor shortages. Opponents point to studies showing teens who work more than 20 hours per week experience lower grades and higher dropout rates. The teen workplace injury rate is roughly twice that of adults. Both sides make valid points that deserve careful consideration. Here are the authoritative legal references. First, the Fair Labor Standards Act of 1938, found in Title 29 of the United States Code, Section 201 and following. This federal law sets minimum wage, overtime, and youth employment standards. Second, Texas Labor Code Chapter 51, Sections 51.0001 through 51.016, governing employment of minors in Texas. Third, Title 29 of the Code of Federal Regulations, Part 570, detailing the 17 hazardous occupation orders. Fourth, the Texas Workforce Commission provides guidance on work permits and prohibited occupations at twc.texas.gov. Thank you for watching this presentation on Texas versus federal teen labor law. Texas law gives 16 and 17-year-olds unlimited work hours at any time of day, with no state limit or work permit required. For 14 and 15-year-olds, Texas allows 4 hours per day and 28 hours per week during school, exceeding federal law. The 17 federal hazardous occupation orders always apply regardless of state law. Stay informed. Know your rights. Full references at dol.gov, statutes.capital.texas.gov, and twc.texas.gov.